Hello and welcome. My name is Peter Afrasiabi. I'm a partner at the law firm of One LLP in Newport Beach, California. I teach at the University of California Irvine School of Law, where I run an appellate litigation clinic. And today's program is in the realm of appeals. It's called Appellate Arguments, Tips from the Trenches. Now, of course, as always, all of the views expressed here in this program are my views and my views only. They are not to be ascribed to my law firm or the university where I teach. But nonetheless, I hope they are valuable and useful to you. And let's get rolling. So you see here on the first slide, the question is, where are we going today? And the big goal in this program is to give you those tips and tricks in terms of how you can be a better appellate advocate, a better oral advocate when you're actually standing at the podium doing your appeal. And so the big goal, of course, in today's program is oral argument preparation in both the technology-based appellate oral argument world, but also in the normal court world that we've all been used to before COVID, and which we should return to post-COVID in some fashion. And so what I mean by this is that the traditional realm of doing oral arguments, of course, is standing in a room at a podium where there are three different judges and you are, 10, 15 feet away from them and you are doing your oral argument. But in the post-COVID world, this has shifted, of course, primarily to Zoom-based oral arguments or another technology like Zoom, where we are using the computer as the medium that mediates our relationship with the judges, and sometimes even a telephone. And so the program today will be focused really on both and how you can use both of these mediums, whether it's an actual room or it's technology, to be the best advocate possible. We will review the role of oral arguments historically and the purpose of them and how they can actually change the outcome of a given case. We will talk about how you prepare for your appellate oral arguments effectively. We will cover the idea of mooting practice sessions, the importance and how you can moot and moot properly to be prepared as the best advocate on the day in question when you show up. We will look at many of the technology issues that are critical now in this post-COVID world. And of course, along the way, we're going to have lots of practice pointers and some do's and don'ts that you can follow in order to have the effective and the most effective appellate oral argument possible for you. The place to start when we are going to talk about oral arguments is to recognize that this really is the last chance in your efforts as an advocate at persuasion, and this is what we can call the last persuasion arrow. And here you see a quote from Chief Justice Rehnquist of the United States Supreme Court from his tenure, and the quote is as follows: "Lawyers often ask me whether oral argument really makes a difference. Often the question is asked with an undertone of skepticism, if not cynicism, intimating that the judges really have made up their minds before they ever come to the bench, and oral argument is pretty much a formality. Speaking for myself, I think it does make a difference. In a significant minority of cases in which I have heard oral argument, I have left the bench feeling differently about a case than I did when I came to the bench. The change is seldom a full 180-degree swing, and I find it is most likely to occur in cases involving areas of the law with which I am least familiar." Now, this is a really critical and important point because what it tells us, and this is true from other judges, the more you do appeals, the more you talk to judges, the more you recognize that Chief Justice Rehnquist's sentiments were not anecdotal or aberrational to him. They are generally accepted and true. And that is that oral argument can make a difference. You can potentially win a losing case. You can potentially lose a winning case. Or even if you can't shift the outcome completely, you can sometimes modify the outcome in a way that even if it's not the true ideal for your client, it can still be beneficial to your client to have a somewhat narrower ruling. And this can be very, very important for clients who are, for example, repeat players in litigating things like, enforceability of arbitration agreements or terms and conditions in employment agreements that affect many, many employees. A modified ruling could have massive, massive value, even if technically you still lose the case. And so the key point to recognize here is that, as you see from Justice Rehnquist's quote, that you can actually make a difference. And so your advocacy, your oral advocacy is critical. And so if we invest in it and we do the things that we have to do so that we can be our most authentic advocate selves, we actually have a chance of making a difference in a case. And that's really refreshing and valuable to know because you know now that when you walk up to that podium, it's not a fait accompli. The case hasn't already been per se decided such that whatever you do doesn't matter, you can actually swing this thing and make a difference. Now, the other thing to unpackage from his quote, as he notes, is that it's often the case that it occurs in areas of law where the judge is least familiar. And so our appellate judges, by and large, are generalists. They hear cases from, criminal to civil to agency and everything, in every subset of all of those. They may have come from a particular background where they had an expertise, but they hear sort of everything. And so if you are, hypothetically, an intellectual property lawyer, and what you do all day, every day for the last 20 years has been copyright trademark litigation, and you are litigating a big copyright appeal, and your judges are generalists, that may well be the type of case where you as an advocate have the credibility to swing it because you are particularly knowledgeable about copyright law, which the judge, for example, may not be. And so you actually can swing a case in that sense. And so recognizing these things, I think, is what's critical for us to be armed up and ready so we can get going.